Good morning. I'm Gary DeWaal, and this is Bridging the Week for April 29th through May 3rd, and today is May 6, 2019. The New York Department of Financial Services was told by a federal court in New York that it could proceed with its lawsuit challenging the plans of the Office of the Comptroller of the Currency to accept and consider applications for special purpose national bank charters from financial technology companies that had no intent to accept deposits. Separately, companies associated with an international cryptocurrency exchange and its affiliated issuer of a well-renowned stablecoin obtained a show cause order from a New York court demanding that the New York Attorney General explain why they should comply with an extensive document request by the New York Attorney General obtained through an ex parte process 2 weeks ago. During this week, FIA will host its annual Law and Compliance Conference in Washington, D.C. I am involved in 2 panels there, one on crypto assets and the other on spoofing. So I can prepare for my panels and catch my train. Let's get started. A U.S. federal court in New York ruled that a jurisdiction at this time to consider a challenge by the New York Department of Financial Services to the authority of the Office of the Comptroller of the Currency to issue special purpose national bank charters to financial technology companies. DFS claimed that OCC's plan to grant so-called Fintech charters violated the federal banking regulator's statutory authority to license national banks in the business of banking because OCC contemplated issuing Fintech charters to entities that did not accept deposits. DFS filed its lawsuit against OCC in September 2018, and OCC moved to dismiss DFS's complaint a few months afterwards, claiming that the court had no jurisdiction of the matter because it was not ripe for adjudication. In December 2017, a different judge in the same federal court granted a motion to dismiss an analogous earlier challenge by DFS against the OCC, also claiming that DFS's complaint was not then ripe for determination. At the time, however, OCC was solely considering the possibility of potentially processing Fintech charters and did not finalize its plans. Subsequently, OCC finalized its Fintech charter program for companies and announced it would accept qualifying applications during July 2018. As a result, the court in the current matter held that DFS satisfactorily demonstrated that there is now, quote, substantial risk that harm will occur, end of quote, if Fintech charters were granted, mainly that state oversight of non-depository money transmitters could be eliminated, and DFS could lose substantial revenue if current DFS regulated entities give up their New York licenses for OCC licenses. As background, the U.S. operates a dual system of banking organizations, some regulated by federal authorities and some regulated by the states. Typically, but not always, OCC is authorized as bank deposit-taking institutions. New York State mostly routinely authorizes financial institutions that do not take deposits. Some of these New York entities are special-purpose trust companies that are expressly authorized to facilitate transactions in virtual currencies and comply with requirements that would be necessary to maintain a BIT license, although they do not technically have such a license. Lawsuits among different government agencies? Is this really the best way to get sensible regulation in the fintech area? Congress, are you there? Companies associated with Bitfinex and Tether obtained an order from a New York court requiring the New York Attorney General to show cause during a hearing on May 6 why the firm should not be excused from providing over 4 years of documents required by an April 24th order of the same court. Previously, the New York court required the associated companies to produce a multitude of documents by May 24th, as well as prohibiting the companies from accessing, loaning, or encumbering in any way U.S. dollar reserves supporting Tether stablecoins. The New York AG had applied for such an order without giving respondents notice or having an opportunity to object, claiming such emergency action was necessary because of the potential danger of respondents compromising Tether's supporting balances to help fund Bitfinex's current operations. Last week, the defendants vehemently objected to the New York AG obtaining the order against them on an ex parte basis, claiming that the lawsuit, quote, was riddled with factual and legal errors, end of quote. Among other things, defendants claimed they had voluntarily cooperated with the New York AG's investigation as soon as they learned about it, had no obligation to maintain a 1-to-1 ratio of fiat currency to the value of each Tether stablecoin, and had not committed fraud or failed to disclose a potential conflict of interest because Tether had expressly disclosed to customers on its website in February 2019 that Tethers could be backed by, quote, other assets and receivables from loans made by Tether to third parties, which may include affiliated entities, end of quote. According to the New York AG, Tether extended to Bitfinex a $900 million line of credit that closed in March 2019. Subsequently, Bitfinex drew down $625 million of this amount to replenish funds that previously Bitfinex had transferred to Tether in accounts at Crypto Capital, a payment processor, in return for Tether transferring an equivalent amount from Tether's reserve to Bitfinex at a different financial institution. At the time, said New York AG, Bitfinex was apparently having difficulty meeting operational needs. Beginning in December 2018, said the New York AG, the defendants expressed concern about $850 million of their funds at Crypto Capital that the settlement firm claimed had been quote-unquote restrained by governmental authorities in Poland, Portugal, and the United States. In papers filed in the New York court, the defendants claimed that the court's grant of New York AG's requested ex parte order denied it due process. Moreover, claimed defendants, nothing is fundamentally wrong with Tethers not being backed one-to-one by fiat currency. A quote-unquote fractional reserve system underpins commercial banking, said the defendants. Moreover, even after the companies posted their February 2019 disclosure, Tethers traded on Marketplace close to their US $1 face value. Currently all Tethers are supported 74% by fiat money reserves and 100% by fiat money reserves and other assets, including a loan repayment obligation from Bitfinex, claimed the companies. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. That's www.bridgingtheweek.com. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.